morning's docket. That is case number 114098 in the matter of Gary Riebschlager.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. As the court is aware that this is an original action in attorney discipline, the panel found that Mr. Riebschlager violated 8.1b, and they found that he needed to correct a false statement that was made in an application for Pro Hoc Vice admission. As far as aggravating factors, the panel found that he should have known that he was violating his duty to the public and it actually caused a delay in a trial. They found that he had been disciplined by the state of Texas on 3 separate occasions and that he had been practicing for over 30 years at the time of the misconduct.
Let's talk about that. He's been disciplined 3 times by the state of Texas. That's the only state in which he's actually licensed, isn't it?
That is correct.
Why is Kansas spending its resources disciplining an attorney that's licensed in Texas?
Well, for guidance on making that decision, we looked at the Franco case, which is found at 275 Can 571. And in that case, an attorney had been admitted pro hoc 1 time and then subsequently filed pleadings that appeared that he had been readmitted pro hoc in separate cases when in fact he hadn't. And in that case, that attorney was indefinitely prohibited from appearing in Kansas on any application for a pro hoc admission or any other means of application. And that is the result that we are seeking in this particular matter. And I believe that it's incumbent upon our office for an attorney who is appearing in Kansas courts to abide by Kansas rules. And one of the rules under 119 is that you have to provide information about prior discipline and or suspensions. And in this case, the respondent wrote that he had not been suspended when in fact he had.
Had the respondent actually been admitted to practice Pro Hoc Vice in Kansas, in Wyandotte County, in the case that this is about?
He had been permitted to appear, and the application, I believe, had been approved, but then...
Approved by the court or approved by opposing counsel?
Approved by the court, in that he was able to show up, and then opposing counsel determined that there potentially was a problem. They brought it to the attention of the court, and we had the hearing in which the judge made the certain findings that he had actually submitted a false application. And then I believe at that point, his admission was revoked.
The other question I had pertains to paragraph 25 of the hearing panel report, prior disciplinary offenses. And in 3 different places at least, it indicates that it was the Texas Supreme Court that had imposed the discipline. And when I looked at Exhibit 5 of what was admitted at the disciplinary hearing, those seem to not be the Texas Supreme Court. Is there something I'm missing about what happens in Texas for discipline? Because, for example, Exhibit 5 on the first page is the State Bar District Number 4C6 Grievance Committee. The other was a Harris. Now, at what point does the Texas Supreme Court get involved? I'm trying to figure out if the finding of the panel is actually supported by the record.
I hope Mr. Riebschlager can correct me if I'm wrong, because I'm not all that familiar with Texas. I believe that they have, similar to our final hearing reports that are submitted, and then the court either affirms or denies it in some sort of manner. And I honestly do not know what that process is.
But that affirmation is not in the record, is that right?
What I was provided from Texas as far as support of prior discipline is everything that is contained in the record.
Do you have any further presentation?
I do not. I would ask that the court affirm the findings of the hearing panel and issue an order that would indefinitely prohibit Mr. Riebschlager from applying for admission in Kansas. Thank you.
Any questions? Thank you, counsel. Counsel, during your remarks, could you give us the correct pronunciation of your client's name? I've heard it done several ways.
Reeb Schlegel. Reeb Schlegel.
Very good.
Thank you.
Thank you.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. We accept what the panel has ordered. We're okay with this court entering the order requested by my colleague. I will tell you that I found out this morning that the State Bar of Texas has reprimanded my client in a public fashion. I, like my colleague from the Disciplinary Administrator's Office, I don't follow what they do in Texas and how they do it. To answer your question, Justice Biles, it's my understanding that they have local offices of Disciplinary Administrator's Office and that the Supreme Court signs off on it, but I believe it was what I'll call a local Disciplinary Administrator's Office, and that's not the term they use, that meted out the discipline that's described in the paragraph you're talking about. That's my understanding. Just like in this case, the local, I call it local offices, and that may be an improper way to say it, meted out the discipline which he accepted of a public reprimand. That's as I understand it.
So getting technical, and I realize we're really in the weeds on this, but is there any reason for you to dispute the finding of the panel that this was the Texas Supreme Court doing it as opposed to the local? I realize it doesn't affect anything.
It doesn't affect it, and I'm not disputing that at all, Your Honor.
Okay.
This is an experienced Texas lawyer, an experienced trial lawyer that had problems in his past a number of years ago. He's straightened out those problems dealing with alcohol and other abuse. As I indicated, he received a partially probated suspension, and that was not reported. I think it's important that you look at paragraph 18 of the panel report. The uncontroverted evidence is that the respondent called the Texas disciplinary authorities and was told that he was not required to disclose the partially probated suspension in applications for pro hoc vice. And I know what you're going to ask me, and you're going to be right. He should have, and he should have put it in there. He knew better. He didn't do it, even though they told him not to. He knew that he should have. He made a mistake, and he didn't do it. And he falls on his sword as far as that is concerned. Also, I think it's important that we look at another paragraph in the panel report, assuming arguendo I can find it, where they talk about he was publicly reprimanded in those other cases before, even though they call it the Supreme Court, it was the local offices. And he accepts the discipline that was meted out then. He understands what he did was wrong, and he has agreed not to appear in Kansas courts, either in the state or in any of the federal districts.
Mr. Ambrosio, when you first stood up, you said that you just learned this morning there was a public reprimand in Texas. That was for this case? What happened
That is
here?
correct. It's
Okay.
my understanding. My client told me this morning he had sent it via email about 30 days ago, and I'm not exactly a genius in working my emails, and I obviously wiped it out, but that's correct.
Okay.
So all I have, with your permission, my client would like to, yes.
Counsel, is there any reason for us to question our jurisdiction to enter into this? And the reason I ask is because the way the hearing panel's set up, its facts, is that it says after the verified application was filed, and I understand there was no opposition initially, so normally that would be automatic that out-of-state counsel would be admitted, but it doesn't quite say that he was admitted in that case. And then when I look at our rule, it talks about out-of-state lawyers who are admitted to practice in a particular case. And I just want to see if we got ahead of ourselves or not.
I don't think so. He was admitted in that case and had performed some work and had a local counsel, is my understanding. And the problem occurred when one day the local counsel didn't show up, and he didn't show up either because the local counsel was going to cover it. And I'm not denigrating the local counsel. That's not what I'm doing. And then they started their investigation, and they found the partially probated suspension. That's all I have. I'm
Counsel,
sorry.
between you and your client, I'd like for you to answer the question. The disciplinary administrator, the respondent, and the hearing panel all recommend that he be indefinitely prohibited from appearing in any Kansas court, administrative tribunal, or agency of the state pro hoc vice. Is that correct?
That is correct, Your
All
Honor.
right. If we were to agree with that, and that would be what we impose, and a year or two from now he says, gee, I would like to be admitted pro hoc vice in Kansas, what would be the steps for him to try to get that accomplished, if you know?
I have no idea. But he does tell me, Your Honor, I have no idea. But he tells me he's not coming back to Kansas. I will tell you that, and I don't know, not to be a smart aleck, but I have no idea what would happen.
Very good. Thank you.
My client would like to address you briefly.
Yes.
Good morning. May it please the court. Honorable Justices of the Supreme Court of the State of Kansas. My name is Gary Rietschlager. I am embarrassed by this situation. I've been practicing law for 32 years. I experienced a very bad time in my life, the turn of 2000, becoming addicted to cocaine and alcohol, and suffered various issues with my state bar, receiving various disciplines, and received a partially probated suspension in 2006, went to various rehabs, and have been in successful recovery since then. I successfully completed my probation and have been in active practice since 2006, and in good standing with the State Bar of the state of Texas. When I was with a law firm in Texas, they needed assistance with a case that was pending here in Kansas. No other attorney in the firm had experience with FELA matters. I did. I chose to accept that assignment. I filed my pro hoc vice with the trial court in Wyandotte County. I disclosed my public reprimands. I did not disclose my suspension because of the probation that was successfully served. I made a brief contact with the State Bar and other lawyers, and they said because you have served your probation, they assumed that disclosure was not necessary. That assumption and that decision was wrong, it turns out, and is wrong. I practiced in Wyandotte County for over a year and a half. I prosecuted that case taking multiple depositions, multiple doctors' depositions. I appeared at multiple hearings. On the date of the pretrial conference, my local counsel did not appear. The local counsel living in Kansas City had moved to Florida. She did not appear. She did not appear for the previous motion for summary judgment hearing. The rule in Kansas is that if the local counsel does not appear, the pro hoc lawyer cannot participate. The only way a pro hoc lawyer can participate is with the presence of the local lawyer. The court denied the motion for summary judgment on the previous hearing. When I appeared by myself at the pretrial conference, I was met with a motion to disqualify by the defense lawyer with this matter. It was 1 week before the trial was set to go. Now, I have my opinions about that motion, but nonetheless, it was wrong what I did. And I should have disclosed the suspension. The Texas State Bar picked up the fact that Kansas complaint was filed. The Texas State Bar filed a complaint against me. I hired counsel in Texas. The grievance panel the way it works, Your Honor, is that the grievance panel is composed of districts. There are various grievance districts throughout the state. Houston has, I forget how many districts, I think there are 2 that are allocated to Houston, and the other major metropolitan areas have, I think, 2. San Antonio, Dallas has 2, and there are other grievance districts. The procedure is that the lawyer has the option of proceeding before the grievance panel or proceeding before a district court. If the lawyer proceeds before a district court judge, then that decision, procedure can be either done by trial by jury or trial to the court, which is then reviewable by the Texas Supreme Court. If the lawyer elects to have his grievance matter heard by panel, the panel's decision is final. In Texas, I elected to go by panel. The Texas grievance panel reduced their charge from all this dishonesty stuff to a failure to correct an application, which is the correct charge. I agreed to that, and I accepted a reprimand in Texas, which is appropriate for this case. I think that I've accepted the Mr. Ambrosio's recommendation that I accept the non-appearance of myself in Kansas, and will abide by that discipline if that is the admonition and judgment of this court. Thank you.
Any more questions?
I'm just curious, when you consulted with the other lawyers prior to filing your affidavit in Kansas, you had a question of whether or not you had to disclose it how did that take place? You saw that you had to disclose suspensions, and you wondered if that was a suspension you had to disclose, or how did that work?
Actually, this wasn't the first, in Kansas case, wasn't the first case that I did that with. The very first case that I filed the Pro Hoc Vice in the very same fashion was a case in California in 2009. And the reason that I did it, made that consult in 2009 is because I had just gotten off that suspension in 2008. And I just started with this firm in 2009, and they'd asked me to go try a case in California, a major death case in California. And so because it was just right off the heels of that suspension, I consulted people about that disclosure. And I filed the exact same Pro Hoc Vice in California, and it was accepted by the court out there.
They had the same inquiry, whether or not you'd been suspended. And you said
that is correct, and I tried that case to the conclusion out there. And so with that backdrop, then in 2000, I think this was filed in 2011. Mm-hmm. I didn't re-ask because I'd previously asked in 2009.
Okay, thank you.
Yes, sir.
Justice Johnson, you had a question?
Yes, for Mr. Ambrosio, I should have looked this up, but if he had disclosed his suspension, would the trial judge have had any discretion to admit him?
I think so. I think the trial judge could have said no.
No. I'm asking, does a suspension in the residential state preclude admission?
It does not.
Okay.
Any more questions? Any further presentation from either of counsel? Thank you. There was no rebuttal reserved. That concludes this case. The court will take this matter under advisement. Thank all counsel.